So, the Supreme Court ruled that the Prime Minister lied to Her Majesty Queen Elizabeth II. We're going to be talking about this on this, and also the impeachment proceedings of Donald Trump that started today. You're listening to Around the World Today, here on Real Terrier Radio Podcasts.
Podcasts brought to you by Real Terrier Radio. Around the World Today here on Real Terrier Radio.
Hello and welcome to Around the World Today, here on Real Terrier Radio. So it's been a weird day, isn't it? However, I'm going to read you what I've put about today, okay? And these are in my own words. Very rarely get this. Actually, you get it all the time. Yeah, I know it's a special episode, and I know it's this episode is replacing the word's disability for this month, because there just seems to be a lot going on. Okay, so today's a good day for law and democracy, not only here in the United Kingdom, but in the United States as well. And finally, it's starting to put that nail in the coffin of the ultra-right wing and the fake news revolution that has helped them get to where they are. Oh, and let's put it this way, it's also helping to stop the hatred, the dismay, and the decisive tactics that they've been using since both Trump and Boris Johnson have, started all of this. So in the UK, you've got the Supreme Court ruling against the Prime Minister, saying the advice he gave His Majesty the Queen was illegal, against the law, expunged, should have never been given. Do you know, the best bit is, if you're going to ask legal advice from someone, surely you would go and ask the President of the Supreme Court first. As she is technically the highest judge in the country. However, he chose to ask an Attorney General, remembering that an Attorney General is a politician of the same party. So it's not like, the Supreme Court judges aren't allowed to be members of political parties, aren't allowed to have political opinions whatsoever. But according to these people, we respect democracy, but we don't respect the ruling of the court. Okay, that's interesting, isn't it? However, here is what they said about Trump. His impeachment is looking like it's going to happen. But here it is.
The High Court of England and Wales, and one from the Inner House of the Court of Session in Scotland. It is important once again to emphasise that these cases are not about when and on what terms the United Kingdom is to leave the European Union. They are only about whether the advice given by the Prime Minister to Her Majesty the Queen on 27th or 28th of August that Parliament should be prorogued from a date between 9th and 12th September until 14th October was lawful, and the legal consequences if it was not. The question arises in circumstances which have never arisen before and are unlikely to arise again. It is a one-off. Briefly, the Scottish case was brought by a cross-party group of 75 members of Parliament and a QC on the 30th of July because of their concern that Parliament might be prorogued to avoid further debate in the lead-up to Exit Day on the 31st of October. On the 15th of August, Nicky da Costa, Director of Legislative Affairs at Number 10, sent a memorandum to the Prime Minister, copied to 7 people, civil servants and special advisers, recommending that his parliamentary private secretary approach the palace with a request for prorogation to begin within 9th to 12th September and for a Queen's speech on 14th October. The Prime Minister ticked yes to that recommendation. On 27th or 28th August, in a telephone call, he formally advised Her Majesty to prorogue Parliament between those dates. On 28th August, Mr. Jacob Rees-Mogg, Leader of the House of Commons and Lord President of the Privy Council, Mr. Mark Harper, Chief Whip, and the Baroness Evans of Bowes Park, Leader of the House of Lords, attended a meeting of the Privy Council held by the Queen at Balmoral Castle. An order in Council was made that Parliament be prorogued between those dates, and that the Lord Chancellor prepare and issue a commission for proroguing Parliament accordingly. A Cabinet meeting was held by conference call shortly after that in order to bring the rest of the Cabinet, quote, up to speed, end quote, on the decisions that had been taken. That same day, the decision was made public, and the Prime Minister sent a letter to all members of Parliament explaining it. As soon as the decision was announced, Mrs. Miller began the English proceedings, challenging its lawfulness. Parliament returned from the summer recess on the 3rd of September. The House of Commons voted to decide for themselves what business they would transact. The next day, what became the European Union Withdrawal No. 2 Act passed all its stages in the Commons. It passed all its stages in the House of Lords on the 6th September and received royal assent on the 9th September. The object of that Act is to prevent the United Kingdom leaving the European Union without a withdrawal agreement on the 31st of October. On the 11th of September, the High Court of England and Wales delivered judgment dismissing Mrs. Miller's claim on the ground that the issue was not justiciable in a court of law. That same day, the Inner House of the Court of Session in Scotland announced its decision that the issue was justiciable, that it was motivated by the improper purpose of stymieing parliamentary scrutiny of the government, and that it and any prorogation which followed it were unlawful and thus void and of no effect. Mrs. Miller's appeal against the English decision and the Advocate General's appeal against the Scottish decision were heard by this court from 17th to 19th September. Because of the importance of the case, we convened a panel of 11 justices, the maximum number of serving justices who are permitted to sit. This judgment is the unanimous judgment of all 11 justices. The first question is whether the lawfulness of the Prime Minister's advice to Her Majesty is justiciable. This court holds that it is. The courts have exercised a supervisory jurisdiction over the lawfulness of acts of the government for centuries. As long ago as 1611, the court held that, quote, the King, who is then the government, hath no prerogative but that which the law of the land allows him, end quote. However, in considering prerogative powers, it is necessary to distinguish between two different questions. The first is whether a prerogative power exists, and if so, its extent. The second is whether the exercise of that power within its limits is open to legal challenge. This second question may depend upon what the power is all about. Some powers are not amenable to judicial review, while others are. However, there is no doubt that the courts have jurisdiction to decide upon the extent and limits of a prerogative power. All the parties to this case accept that. This court has concluded that this case is about the limits of the power to advise Her Majesty to prorogue Parliament. The second question, therefore, is what are the limits to that power? Two fundamental principles of our Constitution are relevant to deciding that question. The first is parliamentary sovereignty. that Parliament can make laws which everyone must obey. This will be undermined if the executive could, through the use of the prerogative, prevent Parliament from exercising its powers to make law for as long as it, the executive, pleased. The second fundamental principle is parliamentary accountability. In the words of Lord Bingham, senior law lord, quote, "The conduct of government by a Prime Minister and Cabinet, collectively responsible and accountable to Parliament, lies at the heart of Westminster democracy." End quote. The power to prorogue is limited by the constitutional principles with which it would otherwise conflict. For present purposes, the relevant limit on the power to prorogue is this: that a decision to prorogue or advise the monarch to prorogue will be unlawful if the prorogation has the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions as a legislature and as the body responsible for the supervision of the executive. In judging any justification which might be put forward, the court must, of course, be sensitive to the responsibilities and experience of the Prime Minister and proceed with appropriate caution. If the prorogation does have that effect, without reasonable justification, there is no need for the court to consider whether the Prime Minister's motive or purpose was unlawful. The third question, therefore, is whether this prorogation did have the effect of frustrating or preventing the ability of Parliament to carry out its constitutional functions without reasonable justification. This was not a normal prorogation in the run-up to a Queen's speech. It prevented Parliament from carrying out its constitutional role for 5 out of the possible 8 weeks between the end of the summer recess and exit day on the 31st of October. Proroguing Parliament is quite different from Parliament going into recess. While Parliament is prorogued, neither House can meet, debate, or pass legislation. Neither House can debate government policy, nor may members ask written or oral questions of ministers or meet and take evidence in committees. In general, bills which have not yet completed all their stages are lost and will have to start again from scratch after the Queen's speech. During a recess, on the other hand, the House does not sit, but parliamentary business can otherwise continue as usual. This prolonged suspension of parliamentary democracy took place in quite exceptional circumstances. The fundamental change which was due to take place in the Constitution of the United Kingdom on the 31st of October. Parliament, and in particular the House of Commons, as the elected representatives of the people, has a right to a voice in how that change comes about. The effect on the fundamentals of our democracy was extreme. No justification for taking action with such an extreme effect has been put before the court. The only evidence of why it was taken is the memorandum from Nicky da Costa of 15th August. This explains why holding the Queen's speech to open a new session of Parliament on the 14th of October would be desirable. It does not explain why it was necessary to bring parliamentary business to a halt for 5 weeks before that, when the normal period necessary to prepare for a Queen's speech is 4 to 6 days. It does not discuss the difference between prorogation and recess. It does not discuss the impact of prorogation on the special procedures for scrutinising the delegated legislation necessary to achieve an orderly withdrawal from the European Union, with or without a withdrawal agreement, on the 31st of October. It does not discuss what parliamentary time would be needed to secure parliamentary approval for any new withdrawal agreement as required by Section 13 of the European Union Withdrawal Act 2018. The Court is bound to conclude, therefore, that the decision to advise Her Majesty to prorogue Parliament was unlawful because it had the effect of frustrating or preventing the ability of Parliament to carry out its constitutional functions without reasonable justification. The next and final question, therefore, is what the legal effect of that finding is, and therefore what remedies the court should grant. The court can certainly declare that the advice was unlawful. The Inner House went further and declared that any prorogation resulting from it was null and of no effect. The government argues that the Inner House could not do that because the prorogation was a, quote, proceeding in Parliament, end quote, which, under the Bill of Rights of 1688, cannot be impugned or questioned in any court. But it is quite clear that the prorogation is not a proceeding in Parliament. It takes place in the House of Lords chamber, in the presence of members of both houses, but it is not their decision. It is something which has been imposed upon them from outside. It is not something on which members can speak or vote. It is not the core or essential business of Parliament which the Bill of Rights protects. Quite the reverse. It brings that core or essential business to an end. This court has already concluded that the Prime Minister's advice to Her Majesty was unlawful, void, and of no effect. This means that the order in council to which it led was also unlawful, void, and of no effect, and should be quashed. This means that when the Royal Commissioners walked into the House of Lords, it was as if they had walked in with a blank sheet of paper. The prorogation was also void and of no effect. Parliament has not been prorogued. This is the unanimous judgment of all 11 justices. It is for Parliament, and in particular the Speaker and the Lord Speaker, to decide what to do next. Unless there is some parliamentary rule of which we are unaware, they can take immediate steps to enable each House to meet as soon as possible. It is not clear to us that any step is needed from the Prime Minister, but if it is, the Court is pleased that his Council have told the Court that he will take all necessary steps to comply with the terms of any declaration made by this Court. It follows that the Advocate General's appeal in the case of Cherry is dismissed and Mrs. Miller's appeal is allowed. The same declarations and orders should be made in each case. Copies of our full judgment explaining these conclusions and a transcript of this summary will be available immediately after the Court rises, and I urge you all to read them with care. The Court will now adjourn.
All rise. So that was Baroness Hill, President of the Supreme Court, so the UK's most senior judge. Here's what Doris had to say.
Unlawful, void, and of no effect.
Well, this is from the BBC.
Jaws are dropping on the floor.
We respect the judicial process.
He was prepared to mislead the Queen.
This is courtesy of the BBC. So, Doris?
The decision to advise Her Majesty to prorogue Parliament was unlawful because it had the effect of frustrating or preventing the ability of Parliament to carry out its constitutional functions without reasonable justification. This is the unanimous judgment of all 11 justices.
There were gasps from the legal teams there. There were tears from the lawyers, Regina Miller and Joanna Cherry.
Good morning. It's a win for parliamentary sovereignty, the separation of powers and the independence of our British courts.
Obviously, this is a verdict that we will respect, and we respect the judicial process. I have to say I strongly disagree with what the justices have found.
be held to account for what it has done. Boris Johnson has been found to have misled the country. This unelected Prime Minister should now resign. Johnson.
In light of this judgment today, a Prime Minister with any honour would tender his resignation.
He does not want to have to answer questions about his disastrous Brexit policy, and in doing so he was prepared to mislead the Queen and indeed to mislead the whole country.
And it seems to me that as a matter of honour, Boris Johnson has to put himself before the Houses of Parliament tomorrow and say, you know, I offer you my resignation, do you accept?
This court has been shown that it's been quite Remain friendly, to say the least.
For once, Boris has actually been held to account, and it's critical. At least there's a unanimous decision about something, so hopefully we can move on.
I have instructed the House authorities to prepare not for the recall, the prorogation was unlawful and is void, to prepare for the resumption of the business of the House of Commons.
I'll tell you, I know him well. He's not going anywhere. Don't worry about him. It's another day in the office. He's a professional. It's just another day in the office.
Yeah, well, tomorrow's another day in Parliament. That's what it is.
So, yeah, as you can hear, there's a couple of responses there. Tomorrow is, or another day in Parliament. According to this, the government will respect. Here's what Boris had to say for himself.
Yes, obviously this is a verdict that we will respect, and we respect the judicial process. I have to say I strongly disagree with what the justices have found. I don't think that it's right, but we will go ahead and, of course, Parliament will come back. I do think there's a good case for getting on with the Queen's speech anyway, and we'll do that. But I think the most important thing is we get on and deliver Brexit on October the 31st. And there's clearly the claimants in this case are determined to try to frustrate that and to stop that. I think it'd be very unfortunate if Parliament made that objective.
I'm sorry, but the man tried to say, and he said it a couple of times even in his press conference with Donald Trump, that proroguing Parliament was nothing to do with Brexit. But then he makes the absurd judgment that the people who brought the judgment about him proroguing Parliament, what he did illegally, were trying to thwart Brexit. But like Baroness Hayes said at the beginning of her summing up of the case and the ruling, this wasn't about Brexit. You had people standing outside the court protesting for Brexit, saying that the court are Remainers. Well, should we talk about the court system? A good judge is blind. That's the only way you can say it. A judge doesn't care what's going on in the world outside. A judge doesn't care about Brexit, and a judge doesn't care about, the infighting in political parties. All those 11 Supreme Court judges, so the senior judges of this kingdom, all they cared about was the evidence put in front of them, the cases put up against to them by the other side, the legal arguments, and the summing up of the Constitution as the law sees it. So anything, even if you go to a criminal court, the judge is blind, the law is blind. The judge has to follow the law and see where the law takes them. And it's the same with any court case.
Which the people want delivered more difficult, but we'll get on.
You say you want to get on with the Queen's speech, but you can't prorogue. The court found that would be unlawful and undemocratic at this time.
Well, I'm not certain that the justices did say that. I think that they certainly thought that the prorogation that we chose was not something that they could approve of. It's an unusual judgment to come to. In my view, Parliament has used prorogation.
According to Johnson, it's an unusual judgment. Well, considering this is the first time that promulgation has been used since the Supreme Court was set up, and the first time that promulgation was used for over 5 weeks.
For many, the prerogative of prorogation is a very old one, and it's not, I think, been contested before in this way. And the main thing is, look, we're going to get on and deliver Brexit on October the 31st. Yes, of course, Parliament will now have to come back, but, we'll respect that and get on with it.
The only problem is he's about to lose all of his votes in Parliament. Here's what Jeremy Corbyn had to say at the Labour Party conference about this.
Court in the land has found that Boris Johnson broke the law when he tried to shut down democratic debate and accountability at a crucial moment for our public life. This unelected Prime Minister should now resign. This crisis can only be settled with a general election. That election needs to take place as soon as this government's threat of a disastrous no deal is taken off the table. And in the coming general election, Labour will be the only major UK party ready to put our trust in the people to have the final say on Brexit. We need to get Brexit sorted and do it in a way that doesn't leave our economy or our democracy broken. The Tories want to crash out without a deal, and the Liberal Democrats want to cancel the country's largest ever democratic vote with a parliamentary stitch-up. Labour will end the Brexit crisis by taking the decision back to the people with a choice of credible leave alongside remain. That's not complicated. Labour is a democratic party that trusts the people. As a Labour Prime Minister, I pledge to carry out whatever the people decide. A Labour government will mean better wages, greater security and more say, putting power in the hands of people. And we will bring rail, mail, water and the national grid into public ownership. Conference, the Labour Party and our movement, thank you for all you do. Thank you for the campaigning you do. Go forward to win an election for the people of this country.
And we also have Donald Trump and Boris meeting.
Fantastic job, not easy, but doing a really good job, and I think he's going to make great progress come October, come November. But great progress for the country.
October the 31st.
The results are going to start to show in November.
Any advice for the Prime Minister as how he should deal with the judges?
No, I think he's dealing very well. Everything I see is what. Look, I watch it very closely. He's a friend of mine. I tend to watch friends closer than enemies, but the enemies you have to watch in a different way.
Mr. President, what was your reaction when you heard these UK Supreme Court decision? What was your reaction?
I had no reaction. I just asked Boris, and, to him it's another day in the office. He's a professional. It's just another day in the office.
Yeah, well, it's tomorrow's another day in Parliament. That's what it is.
We had Boris, the first couple of months I think we were 0 for 7 with the Supreme Court. And since then, we won the wall, we won asylum, we won some of the biggest ones. We've had a great streak going. But we started off, we were 0 for 7, and then as you will report, in fact, the first time we won, you were like shocked that we won. And since then, we've almost run the table. We've won a lot of decisions. So I'm sure that's going to happen to you.
Well, we're not counting our chickens, and we're full of respect, as I say, for the justices of our Supreme Court. But we're going to push on we're going to respect what the court had to say, but we're going to get on and deliver Brexit. I think that's what the British people want.
In other words, he's been very nice to the court, friends. Okay. He has total respect for the court. Yeah, Joe. He's doing
considering here in the United Kingdom, judges aren't appointed by the government and are appointed by a committee of law professionals. And then these names go to Her Majesty the Queen, and then she decides. Not the Prime Minister, and not the President of the United States. Now, Donald Trump's Supreme Court is different. What he did was replace Supreme Court justices with people like Brett Kavanaugh who support him, so he could win. But in this country, judges don't have political parties. They have no political bias whatsoever because they're not allowed. If you are a judge and you're a member of a political party and you're found out, you are removed from your position. So, you know. According to Nigel Dodds, it is this is what he had to say, and this is the leader of the DUP in Westminster. You may remember the DUP because Boris Johnson's government, under the last Prime Minister Theresa May, gave them £1 billion, but they wouldn't give Thomas Cook £250 million. However, another company in Northern Ireland's gone bankrupt, so I'd love to know what his opinion is.
Well, I think it's taken most constitutional experts by surprise. It's certainly a step into the political realm by Supreme Court judges. But look, at the end of the day, the government must respect the rulings of the Supreme Court and abide by them. And so, you know, Parliament will be recalled and we'll be there, as always, to fly the flag and to speak up for Northern Ireland. But the crucial thing about all of this is that it doesn't really change the fundamental facts. You know, we do need a deal with the European Union to be negotiated, and all of these shenanigans in Parliament, all of this manoeuvring by parties to shackle Boris Johnson's hand means that it's less likely that we're going to get a deal, and that's the really tragic part, because we want a deal, but the fact of the matter is they're making it harder for him to get a deal.
When you're the government and you're not negotiating, how can it be harder for you to get a deal? When the EU have come out and said they're not negotiating. Only last week, he's been Prime Minister for 3 months. Only last week he sent them ideas on a so-called deal. But you know, what can you do? Now, Boris Johnson tomorrow will have to go to Parliament and have to answer questions. I'm looking forward to this. Real Terrio will have the full day of parliamentary business on our website tomorrow evening. However, let's move on to our next topic. So, impeachment of Donald Trump. Oh, I know. It's nice, isn't it? This is what Speaker Pelosi had to say about this.
The actions of the Trump presidency revealed the dishonorable fact of the president's betrayal of his oath of office, betrayal of our national security, and betrayal of the integrity of our elections. Therefore, today, I'm announcing the House of Representatives moving forward with an official impeachment inquiry. I'm directing our 6 committees to proceed with their investigations under that umbrella of impeachment inquiry. The president must be held accountable. No one is above the law.
Well, it's a bit different in the United Kingdom because technically the Queen is the law, but in America, when the president's being naughty, they have to impeach him. And looking at it, that's what they're about to do. So, what did Trumpy do? Well, Trump talked to Ukraine, to the Ukraine president, and asked him to spy on Joe Biden and his son. Now, if someone did this in a Middle Eastern country like Afghanistan or Iraq, or even in a South American country like Venezuela, Brazil, Colombia, you know, or even an African country like Nigeria, South Africa, you know, there would be hell to pay. So therefore, Boris has broken the law. Trump has broken the law. So, what I said at the beginning, that this now puts the nail in the coffin, but the only problem is their supporters. How can we get them to see that these people are actually breaking the law and lying. Now, when I was a child, I was taught where law was concerned. Now, we follow the law. A normal citizen follows the law. We don't make the law. The Queen's, Parliament does that. And we don't choose which laws we're going to follow, even if you do break the law. Do you know what I mean? If you break the law, that's on you. You've broken the law. If you can't do the time, don't do the crime. That's the saying. However, we don't decide what we're going to do, what laws we're going to follow, what laws. We don't wake up and say, well, I don't like this law, so I'm not going to follow it. Do you know what I mean? We're British people are brought up, so we're Americans until recently. We're brought up to respect the law, the rule of law. But today just seems to be a bad day for that. The supporters of Brexit, the supporters are seeing it like it's bad. But he lied to you. He said it was nothing to do with Brexit. It was about a Queen's speech. So, to keep mentioning Brexit about Johnson. We really need to get these two new haircuts because they look like each other. But for Johnson to do this, what he's really done is lied. And the country keeps seeing him lie. I looked at a polling data this morning, or this afternoon even, or a couple of hours, an hour ago, so this evening, and 43% of the country wish for Boris to be removed, where 39% wish him to stay. This gets even better from the opposition parties, because there are more percentages that want him to go, and it was broken down into all different categories. Now, back to the UK. We'll have more news on Trumpy next time. That's great. However, Boris Johnson has been given 14 days to explain his links to Jennifer Carull. He's been breaking the law for years, and now he's been caught out. He's been caught out lying. He has been caught, Today he met the Queen. He had to apologise to the Queen. But they're not going to announce this, are they? Do you know what I mean? Would you? Now, Lady Justice Hale. She was the first president of the Supreme Court, and I believe she was the only woman at one point. She's a legal trailblazer. The Supreme Court is not the only male-dominated institution Lady Hale has broken into. In 1984, she was the first woman to be appointed to the Law Commission, a body which promotes reform of the law. There, she has played a significant role in landmark reforms, including the Children Act of 1989. The legislation tells the government and other public bodies to place the best interests of the child at the centre of their decision-making, a groundbreaking protection of child's rights at the time. Lady Hale, who was born in Brenda Hale, that's what she was born as, Brenda Hale, has also been a leading voice in calls for modernise the legal system, and is not the one to shy away from challenging traditions. She has previously objected to barristers and judges being forced to wear wigs in the courtroom, banning them silly and an 18th century dress in the 21st century. My main objection is that they are men's wigs, she said in 2013. Well, I kind of agree with her, do you know what I mean? Of course, that's one of the reasons why early women barristers wanted to wear wigs. It was because they wanted to look like everybody else. But we have got beyond that. What's kind of true, she has an impressive collection of brooches. What's also true. And Number 4. She appeared as a judge on The MasterChef. Well, that's just reaching. She's retiring at the end of the year as well. New fans of Lady Hale would be disappointed to hear that she is set to leave her role as President of the Supreme Court at the end of this year. This is because she turned 75 in January, and the mandatory retirement age for judges in the United Kingdom appointed before 1995. Despite only serving as President for 2 years in her role, in the historic ruling on the suspension of Parliament means that Lady Hale was certainly made her mark, and after today, many suggest that she is deserved to put her feet up. True. 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 Now, you know, I'd like to know what your thoughts are about this. Do let me know. But my last thought is that this man, Boris Johnson, needs to go. His little friend Dominic Cummings living in Russia. He has friends with Vladimir Putin. Isn't this a risk to our British national security? Do you know what I mean? Boris Johnson was born in America. He's the first American Prime Minister. He held dual nationality up until 2015. Isn't he a traitor? Then today he's meeting the President of the United States and they're looking like best friends. Talk about a risk to national security. You know, the Conservatives have never been strong and stable, or have never really, in this time around, helped themselves. But anyway, that's enough of my rant about Brexit and the Supreme Court ruling. Thank you for tuning in. We hope you have a lovely day. Remember, you can visit our Facebook page, www.facebook.com/RealTario. You can tweet us at RealTario. You can send us an Instagram picture at RealTario again. Or you can email me at radio@realtario.com or radio@realtario.co.uk, depending on which one you want. And thank you for tuning in. Remember, you can go to support us and you can donate to RealTario to help us make it a little bit better. Have a good evening. Bye-bye.
Podcasts brought to you by Real Terrio Radio. Around the world today here on Real Terrio Radio.